I've been looking forward to this panel, and it is called The Day After, the Impact of the Election on SEC Enforcement. And our moderator is Anita Bandy, a partner at Skadden in Washington, D.C. Prior to joining Skadden, Anita served for 17 years at the SEC's Enforcement Division, where she held a number of leadership roles, including being an associate director. Welcome, Anita. To her left, Bill McLucas. I threaten every year that I will give no introduction for Bill, but I always give up and give one. But Bill is a partner at WilmerHale in D.C., previously served for more than 8 years as director of the SEC's Enforcement Division, longer than any other director in SEC history. Welcome, Bill.
Thank you.
Next up, Juan Migone, partner at StoneTurn in Washington, D.C. He leads teams on complex forensic accounting and investigative matters, and Juan spent nearly 20 years at the SEC, serving in a variety of roles, most recently Assistant Chief Accountant in the Office of the Chief Accountant. Juan, great to see you. Welcome. Next up, Nader Salehi, partner at Kirkland and Ellis' Washington, D.C. office. Nader also previously served as counsel in the SEC's Division of Enforcement. Nader, welcome back. Great to see you. And finally, Bill White, partner at Allen & Overy, actually I should say A&O Shearman, sorry, in its Washington, D.C. office. He previously served for 8 years in the Enforcement Division as a staff attorney, branch chief, and senior trial counsel. Bill, great to see you. Welcome. And Anita, let me turn it over to you.
Thanks so much, Bruce. I was joking with Bruce that I feel like I need to start the discussion with a shot of vodka or at least a Bloody Mary. But look, all kidding aside, I think there's one thing that's certain based on the events of the last 24 hours, that there really is no uncertainty to who will be our next president. And there's certainty that there will be a change of administration at the SEC. So I think the big question that we're all talking about and wondering about is the one that I think we should start at the top of the hour with is, what does a Trump 2 administration at the SEC look like? Can we look back to Trump 1 as a guide for what we may expect during Trump 2? And I'd like to ask each of you for your thoughts on that. So Bill, let's start with you.
Was there an election? I was watching ESPN last night. Did I miss something? But yeah, look, who knows what the change is going to be other than there will be a change. I think looking back to the first term, probably not a great guide. We don't know what has been in the planning with respect to the 2025 project or whatever it's called. And I suspect that when this administration hits the ground, there may be an entire framework set forth for a whole host of government agencies, including the SEC. Much will depend on who the chair is. And, last Trump administration, you had probably one of the most spectacular appointments of his entire term as chairman with Jay. And who knows what will happen this time. So other than there will be change, it will certainly implicate enforcement, rulemaking, and we can talk about that in a few minutes, but it's going to be dramatic, and the shape and details, who knows?
Yeah, I'll second that. I mean, ultimately, who is appointed as the chairman is going to dictate how the SEC mission is executed. And I think as well, who they appoint as the director of enforcement is going to have a huge impact on the program.
Yep.
Yeah, so not much to add. I mean, we know there's going to be, as Bill said, change. We know the SEC is going to turn right. I think what we don't know is it going to be a turn right along the lines of a traditional change to a Republican administration, or are we going to see a change, all the way right, hard right turn, where, and I don't mean right in the political sense, but in the sense that you have a chairman who comes in not just with a desire to adjust the policy to a more conservative framework, but rather somebody who comes in, and Bill's been looking at this and can talk a little bit about it, to make some of the fundamental changes that you see in Project 2025, where they say it's not about just changing the policies, but we're going to get under the hood and really start changing the way the enforcement division works and adjusting the process and imposing deadlines. And I think we don't know the answer to which of those is going to happen, and we won't know until we know who the chairman is.
Yeah, one of the points that Bill made, I think is really important, which is I'm not sure to the extent that the Trump administration has planned to take over any department of the government, including the SEC. CNN reported last night that Trump had no remarks prepared to deliver in the event that he had won last night, and that's one of the things that delayed him going out. So I'm not sure. I think we're going to get something in the next month plus, which may resemble Project 2025, may resemble the agenda that some of the SEC Republican commissioners currently have been talking about. Maybe a little bit of what happened before, but a lot is going to depend on who the chair is.
Yeah. So before we talk more about specific areas of the enforcement program, I think it might be helpful to discuss just a few points on process and mechanics. Before a new chair takes over, which could go much more quickly given what we saw happen to the Senate. The confirmation could go much more quickly. But before we get to sort of what happens to specific areas of the program, during many of our times at the commission, we've lived through the changing of the guard and the period of transition. And I want to focus our attention on the period of transition. When you're waiting for a front office in the division to take shape, there could be a 3 or 4 person commission. There's a host of senior officer vacancy throughout the division. So what are some of the operational changes that we can expect during the period of transition to the new presidential administration? What can clients, what can folks expect in terms of this transition period? And it might be helpful to just kind of talk basics, like what's the role of an acting chair? What's the role of an acting director of enforcement? What are short-term implications for what gets calendared and what doesn't? So let's talk process and mechanics. Maybe, Bill, we can start with you.
So the president-elect's made it clear that he would, quote, fire Gary Gensler. Whether he can do that or not is an open question after the PCAOB free enterprise case a few years ago. But he can certainly appoint an acting chair and nominate a permanent chair. An acting chair would likely be one of the Republicans. It's unlikely that the existing chair would step back and remain a commissioner. I mean, possible, but for the most part, the chairman would resign upon a new administration. That will give us a 2-2 or Republican-Democrat deadlock. I think in the interim between here and there, you're going to see cases that the staff may be worried about. Tough case, maybe an internal controls case, a la Solar Winds, and they're worried, can we get this approved? There's going to be a push to move cases in those areas, and I don't know what all they may entail. Once, if we have a 2-2 deadlock pending the appointment of a permanent chair, I think you'll see a dramatic change in the kinds of cases. I don't think you're going to see the kinds of penalties, the kinds of theories that we've seen in the last few years. I don't think the staff's going to be able to get through aggressive approaches, and that goes to across the board. The texting cases and the size of those penalties, that's not going to happen, I don't believe. Those are some of the things. The areas of program areas where it might have direct impact, I really don't know. I don't think you're going to see creativity and aggressiveness. You're going to see much more discipline, I think, in tethering the theories and the facts to the law, and the guide for that would be to read Hester Peirce's dissents in some of the cases.
Yeah, I agree with that. I mean, I think during my time at the commission, it was what are the parts of the program that have strong bipartisan support? How do we keep the trains moving and get the votes on things like insider trading, FCPA, egregious Ponzi schemes, investor protection cases, things that have bipartisan support, I think will be the goal, in terms of moving the trains on the enforcement docket. But let's talk a little bit about just broader shifts. I mean, Regardless of political party, I mean, typically no chair wants to be perceived as reigning over a weak enforcement administration. Some argue that we saw a greater shift in terms of, policy priority areas under Gensler than under the prior Clayton administration. Let's not forget that the prior administration brought Ripple, brought the Tesla case. Are we going to see more of a what do we think happens in terms of sort of shift in terms of the program areas? Are we going to see more of a shift from Wall Street to Main Street, sort of back to Mr. and Mrs. 401k? What do we expect in terms of the program area? And, I don't know if Juan or Nader, you guys want to comment on that.
Sure, I'm happy to start. I mean, I think, again, it sort of depends on whether we see a chairman come in who is much more of a traditional mold of say, Jay Clayton, or do we see someone come in who's going to be very much in the mold of somebody who wants to fundamentally alter the way the agency works. But assuming we get sort of a more traditional Republican SEC chair, I think, look, as you said, there's plenty of cases that the SEC has brought and can bring that don't really present significant policy issues, like insider trading cases, financial fraud cases, misstatement cases. There's a lot of them out there. And so I fully expect, again, as you said, if we have a traditional Republican administration, we're going to have an active enforcement division that's going to be bringing cases that are probably not presenting significant policy issues. What I think is going to fall by the wayside, and Bill alluded to this, are going to be cases that really present significant litigation risk, significant policy questions, and raise significant questions about the role of the SEC. And when you look at some of the cases the SEC has brought recently, I think they implicate those questions, and we can talk more about it. But there are lots of internal control cases that I think have been brought that perhaps wouldn't be brought. I think there are cases that involve ESG issues that perhaps wouldn't be brought. But there are also going to be plenty of cases. So I think we're going to have, unless you have a chairman who's, again, somebody who's committed to sort of dismantling the agency, and I think there's still a possibility of that. But if you don't have that, I think you're going to have an active enforcement division. It's just they're going to be focused on bringing cases that are not really presenting policy issues.
I agree with that. I mean, ultimately, we discussed this a little bit. From an accounting perspective, there's still those bread and butter accounting investigations. So the aggressiveness of the staff with regard to what is GAAP or an interpretation of GAAP by the staff is going to change. And so there's going to be a lot of, at least the accounting staff that's going to wake up today and say, what's on my docket and what can I pass through to the next administration, or what do I need to try to get through the current administration before there's a change?
I mean, just to follow up on that, we were having a chat earlier this morning. I mean, so when you look at accounting cases, there are going to be accounting cases where the staff's going to develop a record that shows somebody acted in a manner inconsistent with, clearly articulated GAAP principles. Those cases will still be brought. Yep. Nothing's going to change. There's plenty of those cases out there. There are also cases that are in the pipeline now where you might have something to which authoritative GAAP does not speak. And you have a company that took a reasonable approach. And then you have an SEC staff that says, well, we think a different reasonable approach makes sense. And I think that's the type of case where maybe it gets brought under a Gensler administration, probably doesn't get brought under a different administration.
I agree, yeah.
Yep.
Yeah, and I do think, unless you're going, as Nader said, unless you're going to close the doors on the place, you still need a docket of cases, and there's a lot that have bipartisan support. I think there's going to be a shift to some degree to perhaps Wall Street a bit more than has been, away from ESG, away from crypto, but things that people can point to, the administration can point to show that they're being tough on wrongdoers. And I think the banks, I think, are going to come back into.
You think the texting cases don't show that? That's not them being tough on wrongdoers?
I don't think. Well, were they wrongdoers is a good question, but and how much? But I don't think you're going to see cases like that coming out of no matter who it is on the Republican side. But I do think there's going to be an effort to find cases that are going to make the chair of the commission, the Trump administration, look like they're taking action to help to help ordinary people.
And part of the mission, I mean, you talk crypto, part of the mission of the SEC is capital formation, right? So the current enforcement stance on crypto has a tendency to go against that policy and that mission. So, is the Trump administration going to be more open to maybe blockchain markets and different areas of, crypto that would help in the mission of capital formation in the United States?
Yeah. So let's shift to Project 2025. I think we'd be remiss if we didn't discuss these conservative policy proposals that we've been hearing about over the campaign trail and Project 2025's potential impact on the SEC. There's several notable proposals that we've heard about, including, statutorily limiting the time for the SEC investigations to a 2-year time period with no extensions, eliminating all administrative proceedings within the SEC except for stop orders relating to defective registration statements. Some of that the judiciary has already spoken about, revamping the federal bureaucracy so that more jobs are filled with political appointees under Schedule F. Interestingly, this could potentially go all the way down to the assistant director level, positions that are typically held by career public servants. These are positions that usually are somewhat impervious to political dynamics. So what would be the impact, Bill White, let's start with you, in terms of Project 2025 and some of these proposals on the SEC, including the Division of Enforcement? How would it impact the way the division operates? What can we expect there?
The real answer, I think, is we're not entirely sure because, as everybody knows, the Trump and his campaign disassociated themselves from Project 2025, and it's just unclear whether that is the blueprint of the Heritage Foundation or it's the blueprint of the Trump administration.
You want to take a bet on that?
So I do think there's a number of things in Project 2025 that are going to get some traction, and talked about a couple of them. The statute, we weren't sure as we prepared for this which direction the election was going to go. And one of the things I was going to say is on Project 2025 is even in a Harris administration, I actually do think some form of time limit on SEC investigations was going to get some traction. So I think that will get some traction, whether it's a statutory fix or whether the new chair decides to get ahead of it with either rulemaking or just policy pronouncements. But I do think there's a very good chance that is going to get some traction. Probably not as the absolutist way it's expressed, which is no exceptions. It's probably going to look more like the Speedy Trial Act, where perhaps the commission can the person being investigated or the entity being investigated can waive, or the commission can make a finding to extend the time. But I think that's a real possibility. The other one, to me, administrative proceedings, I think is sort of a done issue. I think it's probably going to happen. The staffing issue, which isn't just limited to the SEC, it's broader throughout the government, is pushing political positions down lower than they currently are. I do think we're going to see some of that. I don't know if others have views. I don't know it's going to go all the way to assistant director, but I do think the question is, it's a lot, again, we keep going back to this, but who's the chair going to be? Then who's the chair going to appoint as the director of Division of Enforcement? And then does that person want to go a layer or 2 layers below and put in people and sort of knock out the career people?
Yeah.
Bill, what is that? I mean, I want to sort of ask you, having been director, what is the impact on the Division of Enforcement if assistant directors are now political appointed figures?
If I had to look at the laundry list of things that have been mentioned, the one potential change that could have the most dramatic impact on the SEC and its functioning is this: we're going to throw out the OPM guidelines and we're going to put political appointees and people that one would call loyalists in all these positions. That to me raises the largest big question about what does that mean? How will that work? What does it mean to have loyalists. I actually believe that we have elections, somebody else is in charge. Most people in the federal government get in line and do their jobs. The question is, what does do your job mean? And does it mean hew to the statute and to the public interest, however that's perceived, but do it in a way consistent with what the law is, what your ethical duties are. That's the big dynamic and the big question to me that is uncertain. And I don't know how far down that concept may be advanced or pushed. I don't think it would be dictated by the director and the chairman. If the characterizations of 2025 that we've heard are true, that would be dictated from 1600 Pennsylvania Avenue. And that's something that is worrisome. One analogy I can give you, and I'll date myself, but I was a young lawyer at the SEC in 1980 when Reagan was elected. And whatever sense the workforce had about Trump, believe me, it was similar when Reagan was elected in 1980. The transition report that had been delivered to the White House recommended the entire enforcement division be disbanded and the enforcement lawyers dispatched to all the regional offices. That didn't happen, but the first few years of the Reagan administration was a dramatic change in the focus of enforcement. What changed, and what I think we probably can all take some solace in, is fraud and bad guys don't go away. In the 80s, you had the insider trading scandals and the M&A activity that literally exploded the SEC's profile, its role, and the Division of Enforcement, the support for the agency, not just in the government, but publicly. And whatever we see happen at the SEC, if the staff sticks to their guns and does their job, you know, things ought to eventually hit an equilibrium where things are fine. Because, as I said, it's not like there's going to be some development where people aren't involved in stealing money, cheating. We don't know what's going to happen in the cyber area. Cyber regulation is going to change one way or the other. The whack-a-mole enforcement approach isn't working. It's a $3 trillion market. You got to figure out, is there a regulatory regime, whether you like it, you don't like it, what's the answer? It can't be to sue everybody in every product where you think we don't like this feature of the product. So crypto, I meant to say crypto, but I actually think this is going to take time. You got to see what the staffing looks like, who the chair is, what the director is. But as I said, fraud and people cheating and people stealing money, it's sort of endemic to our free markets. And because of that, we will be in a position at some point where any worry about, oh my God, they're going to dismantle the agency, that's not going to happen.
Yeah, well said. Any other thoughts before we move on to specific program areas? You mentioned fraud. Fraud's always going to exist, but one of the things, I think one of the hallmarks that we've seen in the last couple of years are a lot of cases where internal controls has been more of a focus. Internal controls has been leveraged. There was discussion about that on the last panel in different parts of the program, right? Not just cybersecurity. We've seen that used in social and governance, ESG-related cases, McDonald's, Activision, or cases that are benchmarked to rulemaking priorities, charter communications, share repurchase case. These are all more controls focused with higher penalties. Nader, I want to start with you because you've handled so many of these cases, both on the public issuer side as well as on the IA side. Do you think there's going to be a rollback in terms of the focus on controls, a shift more towards fraud, a shift more towards something greater, and what does that mean? And then is there going to be a proportionality to penalties? Controls case that have very high penalties, almost reflective of conduct that's worse than controls. And so, can you speak to that?
Sure, absolutely. I mean, I do think there's going to be a rollback. I think what you're going to really stop seeing is some of some of the standalone control cases where, you don't have an obvious articulated harm, but you have sort of a control system that the staff comes in, often with the benefit of hindsight, holds to the standard of reasonableness as they see it, finds it deficient and lacking. It's very hard to defend those cases. It's very hard, unless you're prepared to actually litigate. It's very hard to litigate those cases because it's a mixed question of law and fact in most cases. And so, the staff has, I think, been able to achieve settlements that it probably is unlikely to be able to achieve and is unlikely to seek in a Trump administration. So I think that's true in the public company context. I think we've seen these cases. I mean, I think you observed earlier, we've seen cases like this brought under Republican administrations. It's not like we haven't had controls cases under Republican administrations, but I think you've
like
had...
Endeavor is a good example.
Exactly. Exactly. But I think what you've seen is a massive expansion of that in both the public company context, where we had the Charter Communications case, which I handled, and then we've also seen it most recently in the investment advisory space, like the Marathon case, which I was also involved with, where you had the SEC come in, there's sort of no showing of a fundamental underlying breakdown. There's an assessment by the staff that the control system is unreasonable as they see it. Companies aren't able to really fight that. And so the staff is able to achieve an outcome that I think it wouldn't otherwise be able to achieve. I think those cases are going to really, really slow down. And when they happen, I hope and expect you'll see penalties that are very different than what we've seen in the last few years, where, again, obviously personal bias here, but $25 million on a standalone controls case, it's a huge penalty. It's a huge penalty regardless of the size of the respondent. And I hope and expect we see a lot less of that.
Do you think that there's going to be more willingness to litigate? There's been some judicial pushback, even on controls cases. Virtue was litigating, but IAs always have to worry about collateral consequences, the risk that an injunction is imposed and what that means if you're a registered entity. That said, Virtue was litigating. I mean, do you think, where do you see litigation? Do you think the SEC takes less chances in litigation? Do you think that there's parties that are going to be more likely to litigate on controls?
Yeah, I do think that you're going to see people being willing to litigate more. I think that there's a bit of a loss of stigma associated because of what's happened over the last few years. It used to be that for many companies, if you litigated with the SEC, that was a death knell. You couldn't explain to your board, you couldn't explain to your investors. I think it's become easier to explain that people can achieve better outcomes through litigation. And so I think the more you see litigation happening, the more you see opinions like the SolarWinds opinion, I think people will find it easier to explain to their boards and to their constituencies why litigation is an option they should seriously consider. And I think you're going to see the SEC under a Trump administration less likely to pick cases that people will fight. And I think they're going to look for more down the road.
Part of the
cases.
issue with regulated entities will be if you get a different approach on collateral consequences, you'll see more litigation. The reality with regulated entities is even if you believe you've got a 70-30 probability of winning, that 30% downside is enormous if you fear the staff's going to use the collateral consequences to put you out of the managed funds business. So if those things change a little, then I think you're going to see more regulated entities, big banks, big investment banks, prepared to take on some of these theories, which is why I think some of the theories they're going to pull back on.
More willingness for IM to grant 9A
Right.
waivers. There may be.
Right. I mean, when you think about it, the merits become less relevant when your assessment is, can I risk basically being shut out of business because of a collateral consequence?
Right.
I think that'll keep being the main thrust for regulated entities. One of the things that goes into the mix, though, is I do think over the last 8 years, the federal judiciary, which will be the only place these cases are handled, has changed. The traditional path to federal judgeship involved being a prosecutor and sort of having that bent. That was not fully the case in Trump's appointments. His appointments didn't completely follow the mold. There's some, but And then I actually think that continued on with the Biden administration, where there were a lot of more appointments that weren't just that sort of prosecutor mindset. So you might be looking to see, what do you get for a judge? Who do you get for a judge? And how might it come out? Although, again, for regulated entities, I think you end up going through that analysis and you're still stuck at settling, at least in the current environment.
Yep. Let's move to a different area of the program that's been a real focal point of the current administration, which is ESG. Earlier this year, the SEC chose to stay the newly adopted climate rules. That's pending before the Eighth Circuit. We've heard reportings that there's the dissolution of the Climate and ESG Task Force within the Division of Enforcement. And then there's also, social and governance issues. There's the NASDAQ board diversity rules that have also been adopted. So there's climate as well as social governance, in terms of focal points of this administration. Despite climate somewhat being halted, we've seen enforcement using its existing authority to, certainly highlight its priority in this area. Recently, we saw the Keurig Dr. Pepper case being filed for inaccurate statements regarding the recyclability of K-Cup single-use beverage pods. And we've talked about social governance issues like Activision, McDonald's. There's a recent board independence case that came out. This is an area where, some have questioned issues of materiality in terms of, does this matter from an investor protection standpoint, from a materiality threshold perspective? A real, I think, political issue that we've heard the Trump administration push back against. And so, is this an area where we can expect to see a real rollback? I mean, or do we think the judiciary is going to, the issue gets played out by the judiciary as opposed to a new commission coming in and completely rescinding the rules, as what we saw, quite frankly, with this administration and the proxy advisory rules, right? Like under the Clinton administration, that was a promulgated rulemaking that this current commission completely just came in and rescinded. And so are we going to see some of that take place with ESG? Cybersecurity, other rulemakings. So any thoughts on that? Maybe Juan, we can start with you and really invite everybody to share thoughts.
Yeah, I mean, in terms of the ESG rulemaking, I would be a little concerned about that rule being rescinded. It specifically indicates that you don't have to make disclose scope 3 emissions. Now, you have a regulatory body in Europe and certain states that are requiring certain disclosures. So with that exemption not being there, to the extent you make disclosures in Europe or to certain state regulatory bodies, are you going to have a requirement to then disclose that in your own filings? Is that going to be like a Reg FD violation if you don't? So that's where I'm concerned from the ESG rulemaking perspective, more from the company side. What am I going to actually have to disclose because I've made disclosure in Europe or elsewhere?
Nader?
Look, I think when it comes to ESG, but sort of on rulemaking, I think there's going to be a fundamental change, and I think whether it happens because the agency chooses not to pursue some of these initiatives or because the courts force them to, I think we'll see. But either way, there's going to be a fundamental shift. I think on the enforcement side, there's also going to be a shift, but I don't think it's going to be as fundamental in the sense that, look, you're still going to see what people call greenwashing cases. I think they're just going to be labeled, false statement cases. Like you're going to see cases where, people have made statements on issues of ESG or other matters that investors take seriously, and then investigations show that those sort of statements weren't truthful. And so I think those cases will continue to exist.
Like Volkswagen was prior administration case.
Exactly. Mm-hmm. But I do think that there are going to be cases like the Keurig case that aren't going to be, I hope and expect, and I'm not involved in that case, that those cases won't be brought, because to me, that's a stretch case. And I think that's exactly the type of case where, a different administration could look at that and say, I'm not sure that protecting investors as part of the mission statement of the SEC involves understanding whether two states really did or did not think these K-Cups were commercially feasible as a recyclable item. I don't know if that's the case.
Yeah.
Bill, you look like you were going to disagree with me.
No, not at all. I was just going to move to cryptocurrency. I don't think this panel can get away from talking about digital assets, which has been a huge priority, top priority for this administration. While, we've also heard Trump openly talk about wanting to declare the United States as the crypto capital of the world. And so, very different tenet. We also have been waiting for more guidance on exemptive authority legislation, whether the authority is going to reside with the SEC versus the CFTC. Recently, there's a crypto firm that utilized a lesser known rule that allows a market participant to ask the CFTC and the SEC through a declaratory action whether a product is a swap, a security-based swap, or a mixed swap, and kind of forcing the agency's hand to issue some interpretive guidance. So are we going to see more proactive litigation as we wait for legislative action? Are we going to see a rollback? What are thoughts? And should these crypto platforms really be following standards that fall under AML, Bank Secrecy Act, those parts of sort of enforcement bodies? So I'd love to elicit views from the whole panel. I mean, maybe Bill, we can start with you in terms of crypto.
Look, I can understand the number of the SEC's cases, the product fits within the Howey definition, it's a security. The problem is that can't be the solution, because whether you like crypto or you don't like crypto, it's not going away. The enforcement cases that have been brought are what they are, but they keep bringing them, and we keep seeing crypto products. So the likelihood, whether whomever won the election, there's going to be a change, in my view, in the approach to crypto, and it's going to have to involve a rule proposal with regulatory responsibility residing either in the CFTC or the SEC, and notice and comment, and the regime being whatever it's going to be. There is a risk. There's a huge issue here about money laundering, tax evasion, terrorist financing. That's not de minimis. It is very real. And I think that the challenge for the government is, what's the regime? How do you worry about all those things, impose the appropriate know your customer standards, and deal with this emerging industry? I think we've lost a couple of years by doing it by enforcement. But that's where we are today, and I think that's where this thing's going to go.
Yep. Juan?
I fully agree. I mean, I can't state it any better than he just did. So.
Yeah, I would just echo Bill's comments. I mean, I think there's the question of who's going to have the responsibility. I think we all agree somebody needs to. And I think that crypto's not going away, and nor is the fraud that's going to potentially occur in that market. So we do need clarity on who's going to regulate it.
And I think that's going to take some time. That's not, I don't think, a January 20th thing. And there's always the possibility of some sort of executive order. But I don't think that's the way this is likely going to go. Those things have to get hashed out. It's going to take a little bit of time. But one of the things, just from going away from the SEC and just looking at the politics of the situation, it's rare that one industry has sort of gone all in on one side in the election, as they did here in the crypto industry. And so I think there's going to have to be some progress. I think it's going to take some time, but they're going to have to show some progress to getting to where the folks said they need to get to, either by rulemaking or whether there needs to be some legislation first and then the rulemaking, which probably be the smart way to do it. But
yeah. Let's spend some time talking about corporate penalties. I mean, we've touched on the topic, but we've seen, really record-breaking penalties, often for controls or more technical violations. I think that applies both to the IA side as well as the public company side. What do we expect to see in terms of corporate penalties? Typically, that is an area where we have seen a marked difference, administration to administration. So Bill, maybe let's start with you in terms of your thoughts.
the texting penalties and we had COVID, we had everybody working at home, we had people using their cell phones. It's not to excuse it, but really look at the numbers associated with those cases. I just thought they were disproportionate, and it is what it is. I thought it was a bit of an overreach, and I think that is in part what contributes to some of the backlash.
Yeah.
And I think penalties are going to come down.
Yeah, I agree with that, and I guess what I would say on penalties is not just that they can and should come down in many contexts, but I think what's been missing is a lack of understanding as to how penalties are calculated and how they're calibrated to the particular context. And I know the staff has spoken on this and has articulated its viewpoint on sort of the methodology that leads to the penalties that have been imposed. But I'll just say from this side of the fence, when we're talking with our clients, there's a substantial lack of sort of clarity on what penalty we're going to land at, why we got there, and how it sort of connects to the conduct. It's often been articulated as a penalty that needs to be big enough to hurt. I'm not sure if that's the right metric.
To Nader's point, it's not unusual to have a conversation with the staff and you say, how did you get to this number? There's a variety of factors. Well, that's enlightening. Can you help me? And you get something fuzzy and you say, look, I've got a public company and a board of directors who've got to make a fiduciary decision here. And you get no more enlightenment other than that we think it's appropriate.
Yeah.
And I think also what's going to drive it is who's driving the penalties. Is going to be the staff, the front office, the commission, and what messages they want to send.
Yeah, I think one thing we're also going to expect to see is much more of a focus on what's the corporate benefit, right? What's the corporate benefit? So FCPA penalties may be easier to get through than other parts of the program, especially disclosure cases, where there really isn't a proportional connection to shareholder harm or a corporate benefit. So I think that we can certainly expect to see more of a focus in terms of assessing the penalties. The other interesting thing is that, at the end of the day, the division should be beholden to the statutory framework. And for cases that we've seen that have litigated, even if you look at the shadow trading case, right, person, found to have violated 10B insider trading, but judge refused to issue an O&D bar. And the penalty was within the confines of the statute. And so, are we going to see more of a benchmarking to what you're reasonably likely to get in a litigation that a district court judge would order? Maybe an area that's more considered.
Yeah, I mean, I think, just to pick up on that for a moment, there's a lot of ways to drive corporate action for an agency like the SEC. And I think, and I hope, that under a different administration, they will be more sort of judicious about using enforcement as the only vehicle by which you can drive corporate action. In other words, if you take the texting example, there were a lot of ways, I think, for the SEC, if it wanted to make the point about texting. Mm-hmm. There could have been speeches, there could have been exams, there could have been pronouncements. I would argue they probably could have gotten to the same place without imposing the penalties that they did. And I understand that the penalties have other sort of outcomes that the speeches and the exam program don't. But I think we just need to remember the SEC can drive conduct lots of ways. Yep. Enforcement penalties is just one of them.
And on penalties, I agree with everything everyone said, but I'd put a marker down on cases, and just goes back to what we said in the beginning, but on cases where they can look like they're protecting Main Street, where they're protecting the public, where there's some real risk. I wouldn't shock me at all if the penalties were, in those cases, were not lowered very significantly, but were high. But generally, I agree they're going to go down. But I think they're going to need to show some level of toughness, as we talked about before, and it's going to be where they decide to pick.
Okay.
I agree.
In the last, sorry, Nader.
No, I was just saying I agree, sorry.
In the last minute, I wanted to just get thoughts on predictions in terms of how soon a new chair will be in place. I mean, with the Senate now falling into the hands of the president-elect party, it may be a lot sooner than what we're used to. So any predictions in terms of how long the tenure of a 4-person commission will last?
I would say sooner than we would normally see in a change of administrations, which is usually summer to fall. I think this one's going to be quicker. What that means, I don't know.
I don't think we're going to see a 2-2 commission. I think that we're going to have a full commission.
Any predictions on when the new chair will be coming in?
As soon as he can be appointed.
Yeah, I would agree with Bill and say I don't think we'll get to the summer without a Republican 5-person commission.
Yeah, that timing's probably right. The one thing we've got to look at, though, do we get a more traditional establishment commissioner, or because of the control of the Senate that Trump has, do we end up with sort of more of a wild card in there as chair? And so I think that's yet to be determined.
All right, well, I think we're at time. Thank you.
Thank you.